So thank you all for joining us for this teleconference hosted by MS Focus, the Multiple Sclerosis Foundation. I'm your host, Casey Minnis, Director of Communications for the Foundation. And today I am joined by Michael Wild, Esquire, who will be speaking on the topic of estate planning and asset protection for those with special needs. Let me tell you a little bit about our speaker. Michael D. Wild is the managing partner of Wild and Felice Partners, PA, and a leader in the local community here in South Florida. He serves on the board of directors of 211 Broward, Handy, ARC Broward, Boys and Girls Club of Broward County, and the Nova Southeastern University Ambassador Board. He also chairs the endowment committees for ARC Broward and 211 Broward. He's chaired the March of Dimes Signature Chef Gala and the 14th Annual Joint Tax and Estate Planning Seminar and the 211 Broward Making Real Connections Breakfast. Michael was admitted to the Florida Bar in 2006. Prior to obtaining his law degree from the University of Florida Levin College of Law, Michael earned his BA in Political Science with a minor in Sports Management, also from the University of Florida. In addition to earning his undergraduate degree and law school degrees, Michael has worked as a financial associate with Alliance Bernstein and as an operations assistant with the Miami Dolphins. With genuine enthusiasm for his work, Michael is a frequent speaker to advisors and clients on the subjects of estate planning, wealth transfer, probate administration, and asset protection. He prides himself on implementing a holistic approach to planning, treating his clients like family and working with them instead of talking at them. We're so pleased that he's with us today to present this very important information. So now, Michael D. Wild, I turn it over to you.
Great, thanks so much. So as we were just talking about, as Casey was just mentioning, the normal way that I would give a presentation is when I'm live, people would be interacting with me as I'm talking. So if anyone does have any question or comment, it's new. The Zoom thing is new to me as far as giving presentations to such a large crowd. So if you do want to chime in at any time, please do so. I think we were talking about the ability to either comment or raise hand, or I'm not exactly sure what makes the most sense, but however you'd like to, chime in is welcome. So with that being said, and let me just kind of put it on gallery view so I can kind of see everyone also. All right, so my name is Michael Wild, and I own and manage a law firm here in Plantation, Florida, in Broward County, that handles estate planning, asset protection, and probate administration. That's all we do. So we're specialists in that area. One niche that's carved out under all three of those areas is that niche of special needs, not just trusts, but assisting with the qualification for both federal and state disability, Medicaid, and things like that. And obviously that's pertinent to what we're talking about today, but don't let that limit your questions or comments, because if you have any questions in the areas of estate planning or asset protection or even probate administration, I'm happy to take those questions as well. So one of the things that people worry about, I should also say, we're not a Medicaid application company. We don't fill out applications. We don't send in applications. What we do is work with those companies to form the legal documents that help people qualify. So just if you have any questions about that stuff, I may or may not be able to answer it, but that's not really what we do. One of the main things that people forget when they're focused on setting up, for instance, a supplemental needs trust, be it a first party or third party trust, is the actual person that it's benefiting. And I think that's one of the things that really takes the most time in one of these consultations, is not just how do we get the money, how do we qualify for the money, and taking the beneficiary out of the equation. What we really need to think about is the life of that beneficiary if something does happen to the person who would normally be taking care of them. And when we're thinking about that, a lot of times we're thinking about minor children that have disabilities, but also, those that are adults but have guardians and are not able to function on their own, either living at home with a relative or even in a group home. So when we think about that, and especially if I'm talking to parents and they're saying, okay, well, I want to make sure my child is able to qualify for public benefits. That's one part of it. But who's going to take care of your child is another part of it. It's not enough, as I would do with my clients of any type of minor child, to name a guardian in your will. That would only go until 18. When we have to then appoint a guardian ad litem, or through the courts, or where we have to have someone apply to be the guardian of an adult person, that's something to take into account also when we're thinking about the estate planning aspect of supplemental needs. The other thing is not just the who takes care of the person, but who actually manages the money. So a lot of times people will come in and when you're setting up a trust, and by the way, everyone should have a trust. The trust, the probate is an awful process that should be avoided at all costs. It's very expensive, very time consuming, and a basic trust will alleviate that concern. But when we're talking about creating a trust that does have a supplemental needs component to it, if it's for a beneficiary, a future beneficiary, a testamentary trust, then that's one thing. Then we can put in the language necessary to keep that beneficiary on benefits, or to make them eligible for future benefits should they need them or should they choose to apply for them. But who is the trustee of that trust is very important as well. A lot of times people will say, okay, well, I'll just put, their brother as the beneficiary's brother as the trustee, or the uncle as the trustee, or the aunt as the trustee. And I say, well, do they have any experience in dealing with Medicaid, and dealing with the Social Security office, and dealing with these restrictions on distributions and what can be purchased? And a lot of times they don't. They have none. And so the question then becomes, okay, do we want to educate this eventual successor trustee now? Or do we want to choose someone who already has this experience? Sometimes it makes the most sense to pick a professional, especially a corporate trustee. I'm a big fan of using corporate trustees for supplemental needs trusts, making sure, though, that the corporate trustee also does have some type of department that specializes in that. There are some really good ones locally that don't cost an arm and a leg. Even Wells Fargo actually has a really good department when it comes to dealing with Medicaid and things like that. But, Comerica is very popular as far as a corporate trustee that handles a lot of Medicaid situations. Also, Coral Gables Trust has a separate a department segregated for that. Irrevocable trusts are one thing, restricting a child and making sure that the beneficiary can't access money, but then making sure you're not disqualifying that beneficiary by doing something that is that's disallowed by the restrictions of Medicaid or Social Security, disability, or any other benefit that they might be receiving, is also very important. And these big companies, they're on top of all of that. So the big banks and trust companies, they keep current with those, with those restrictions. Attorneys can sometimes act in that role. I don't prefer to. When personally, I will act as a trust administrator if a client doesn't have someone to administer the money at the time of their death. But I don't like to act in the role of trustee when someone is trying to qualify for those benefits. Some attorneys will, especially some attorneys that also focus on the Medicaid practice itself and making those applications. They have to stay on top of that stuff. But the liability is pretty high if the trustee does make a mistake. So we don't want. But my firm specifically, we choose not to be the trustee of any supplemental needs trust. We will, when we act as an independent trustee for any long period of time, it's usually from a standpoint of, okay, you know, my kid can't touch it till he's 45, and until that time, he's got to ask you for permission. It's more of the what, you know, if the child wants to buy a car, we make sure it's a Toyota and not a Porsche, you know, that something like that. So we make it, you know, it's more straightforward, less about government restrictions.
Michael,
Yeah.
we have some folks who are having a little bit of problem with the terminology.
Oh, sorry.
So in the chat, what is a trust? What's the difference between a trust versus a will? What's the difference between an executor and a trustee?
Okay, perfect. And thank you for reminding me to open up the chat window so I could see that now. Okay, so I'm going to take some of these questions right now. What is a trust? So a trust is simply a contract. Now there are many different types of trusts. You know, the type of trust that is most common is a revocable trust, which you set up for yourself. It's a contract between the grantor, the person who sets up the trust, the trustee, the person who administers or manages the trust, and the beneficiary, the person who benefits from the trust, who gets assets from the trust. When you have a revocable trust, you are all three. When you create a revocable trust, you are the grantor setting it up, you are the trustee managing it, you are the beneficiary benefiting from it. That's for a revocable trust. However, for a client that's trying to qualify for any type of benefit, a lot of times they can't be the trustee of their own trust, or at least they can't be all three. So to qualify from an asset standpoint, they have to use an irrevocable trust. And so they are going to be the grantors because it's their money going into it. Usually they remain as beneficiaries benefiting from the trust, but somebody else has to be the trustee. A lot of times it's an adult child or a family member or someone trusted to act in that role. So the trust itself is just a contract, and it can be stipulated in any way you want. So if you're not worried about benefits and applying for those and qualifying for those, and it's just a matter of, okay, well, I want to make sure that my kids don't, you know, squander the money away, or I want to make sure that my daughter-in-law or son-in-law doesn't have access to it, we can do that through the document itself. And basically, if it's not, as long as it's not against social policy. So as long as you're not saying, okay, if my son kills somebody for me, then he can inherit, then the contract will be upheld, and it's got to be executed in the proper way and funded in the proper way. But it works to assure that your assets are going to transfer to your beneficiaries upon your death without having to go through the court system, and also avoiding creditors and litigation and things like that. So it's very important. Now, a will is not important unless you have a minor child, because a lot of people think a will is the document that appoints property to the beneficiaries free of probate. Actually, the definition of probate, which is, kind of the taking of assets from the deceased person and transferring it to the beneficiaries, but through the court system, is the proving of the will. So anyone who has a will, that will has to go through probate. What we don't want is we don't want the assets to go through probate. So two reasons why, now if you have a minor child, a will is important because you appoint a guardian for your minor child through the will, but two reasons why the will is probably the least important of the estate planning documents we draft is if you have liquid assets that you're naming adult beneficiaries on the beneficiary designation, your will won't trump that. Your beneficiary designations are always going to happen before the will. In fact, joint ownership happens first. So if someone's on an account with you, which I don't recommend, by the way, they would get all of it. Your will would not matter. If someone's a beneficiary, they would get all of it. The will would not matter. So the will can only work on assets that are in probate. And we don't want assets to go in probate because probate usually takes between 6 and 18 months. If it's not contested, usually costs between 7 and 10% when you take everything into account between lawyer fees and filing fees and creditor claims and things like that. So we want to avoid that. So, everyone should have at least a basic revocable trust because probate does kick in at $75,000. A lot of people think, well, I'm not a millionaire. $75,000 is the point at which a trust is necessary. And then the type of trust is what we would talk about based on the goal that's being met. So if your goal is like my goal, which is I have an 11-year-old and a 6-year-old, and I don't want them, spending all the money at 18 or doing something stupid. I have restrictions in my trust. Avoiding probate is one of those things that I want to achieve. Another thing is just making sure that until my kids are 30, that's the age I chose, that they would not have complete access to that money. They would have to actually ask permission from the trustee, who I've listed as my father, to make decisions as to whether they should spend the money or not. In my trust, I've listed things that I want money to be spent on, such as education of any kind at any level, health, maintenance, support, things like that. But then if my son wants to, drop out of high school and take his money and try to, open a business on the beach, then my trustee would say, no, the goal is, go to college, get your degree, things like that, unless it's a great opportunity, in which case maybe the trustee will say yes. But the trustee, who you name, like I mentioned before, is very important, because that's the person that's going to carry out the wishes. That's the person who has the discretion. So when we have the difference between, a will and a trust kind of work together. The will pushes anything in probate to the trust, but the trust really is what should own all the assets. And that's what's going to give protection, not just from probate, but from anything else: divorce, creditors, litigation, bankruptcy, and things like, Medicaid, Social Security, disability as well, as long as it's drafted in the way that it needs to be, a supplemental needs trust. And then just to go down the list of the questions, the person that's responsible for distributing, that is the trustee. So somebody asked about the person who'd be responsible for distributing. So that's why, again, it's very important to pick the right person, someone that you trust to make the decisions you would make if you were still there.
That was actually me. I was trying to answer.
Oh, you were answering. Okay.
Yeah, sorry.
Gotcha. No, that's perfect. I appreciate it. Okay, so then someone asked if a trust is only for those under 18. No, that's actually, the guardianship would, in the will, would only be for someone under 18, because the trust itself is for any beneficiary. So it's actually even yourself. Again, we did a trust, in fact, just before I got on this call, we just did the signing for it. A woman who is not sure if she's going to need to apply for, or can even qualify for, federal benefits. And what we did was, she wanted to have a revocable trust, but she wanted the option of converting it into what is an irrevocable investment trust or a grantor trust to qualify for Medicaid. Now, for her, she might have two issues. One of them is an income issue. One of them is an asset issue. They're completely different. As an asset issue, what we do is we want to make sure all of the assets are in the trust, because right now it's revocable and it doesn't restrict her in any way. Her son is a co-trustee, and if we want, we can just shift the track, kind of like the train track that goes in two different directions. We shift it. We have a clause in there that says she can just convert it to irrevocable, and boom, now it qualifies her assets. There's no clawback on that, because she's moved the assets already, as long as 2 years elapses, from the time she transfers it. As far as the income issue she may have, and she's trying to establish whether or not she does have that issue, that's what's known as a Miller trust. So an income trust is different, because an income trust or a Miller trust is just used to qualify for Medicaid. It doesn't actually protect the asset. What happens is the income, usually annuity or retirement income or Social Security income, goes into the trust, and the excess income stays in the trust and can be clawed back and reimbursed to Medicaid after that person dies. So it's not a way to protect the assets, whereas the irrevocable trust we're creating for this person is actually supposed to protect the assets for her two sons, who are grown. And then, beyond them, the grandchildren and things like that. Then I saw, okay, do you cancel your will after the trust is made? So the answer to that is no. Even though you have a trust, you still do need a will. But as I point out to my clients, that the will, because it's just pointing assets to the trust, is much more vanilla and much shorter. It does list who the personal representative is. It does list a guardian for any minor children. And it does say, if I forgot to put anything in my trust while I was alive, put it into my trust after I die, and to work as like a funnel to make sure everything does get in. It doesn't avoid probate at that point, but it does at least get the assets into the trust. And that's important because a lot of times what the trust is doing is not just avoiding probate, but protecting, from son-in-law, daughter-in-law, making sure grandkids get it, making sure nobody too young has access to it, things like that. So it's important to still have the will. But another reason why a will is as vanilla as we create our wills as vanilla as we can is because it's the only document that becomes public record at the time of your death. So the trust is completely private, cannot be challenged, cannot be, as long as it was executed the right way, cannot be challenged, cannot be, it's not a public document. We had a very high profile client die in a very public way, and his estate, there were assets in the estate. The TMZ was publishing the will over and over and over again, but they didn't have any access to the trust, so they couldn't see who the beneficiaries were, and they couldn't see what kind of stipulations he had put in his trust. And that was important because when he passed, his mom was like, "Oh my God, TMZ has the will," and I was like, "What? That's fine. That's why we create the will that way. The only thing the will shows is who the kids are, like who someone is married to and who their kids are, and that they have a trust. That's it. Everything else is completely vanilla on purpose for that purpose."
I have a quick question for you since before you move on. So how do I have people that are in my group that have MS, they get Social Security disability, but there's a couple of them that also get compensation from the military, disability compensation. Do they need a trust in order to protect that if for some reason they use Medicaid? Medicaid can't really pull those funds back, right?
Well, yeah, so it's all whether it's treated as income, and I think that probably is treated as income, right? Are they treating
it's non-taxable?
Okay, well then maybe it's not. Maybe it might be.
This is service-connected disability I'm talking about, not retirement. I'm talking about service-connected disability that they get a 1098, so they report it, but it's not something that's wageable.
So I haven't had that issue before with a service member receiving disability on top of the what you would normally apply for. So it really, what I would say is it depends on if it's treated by Medicaid as income or asset. Because if it's treated as asset, it's no problem. Like then it comes in, they spend it, there's no issue. If it's treated as income, it is added to the amount of income they receive, because even if they don't pay tax on it, they still would treat it as, like even like a Roth IRA, you wouldn't pay tax on, but it's still income to you. I think that it would be treated, I mean, if it's exempt as income, that's great. It just sounds very similar to like what would come in as a Roth IRA distribution, which would be income. The positive of that is that the overall amount, I don't know if they get like Social Security income where they get just a check each month, or if there's a pool that they're drawing from. A lot of times people worry about there being a pool of money in their name, like an IRA or an annuity or something like that. And those assets are treated as income, not as assets, which helps. But in this case, I'm not exactly sure if it is treated as income, because it sounds like there might be an exemption for it, but it sounds like it's very similar to those non-taxable benefits that a client might be receiving.
Well, and the problem is that he's getting it tax-free, and he was able to invest it into a Roth for his wife.
Oh, gotcha.
But it's in his name. So I'm curious if I need to tell him that he needs to talk to his financial advisor, his tax guy, or what he needs to do with it.
Now,
it sounds like it's not going to get protected.
It sounds that way based on, all the information I have thus far, but I would be curious to see has he tried applying yet and been denied?
He's got Social Security disability he's getting.
Oh, so he's getting SSD. So then it must be exempt then, because if he's getting the SSD, it's the same qualification.
Okay, so this is other than SSDI.
Yeah, exactly. It's because SSI would count as income, but SSD would not, and so this might just be another benefit.
Yeah, he's just disability insurance, so he doesn't have to worry about it anyway. Okay.
Yeah, I think then that would be exempt then. I don't think now whether or not it accumulates and becomes an asset issue, that's a different story. But I think it might be exempt from an income issue then, based on
Okay. All right. Thank you.
no problem. Let's see if there are any other. I think I got all the questions that were written here. So what I was talking about before, as far as the setting up these trusts, a lot of times the focus is death. Where okay, if I die, I need my beneficiaries to be protected, or applying for benefit right now, saying, okay, well, I know I need it, the at-need Medicaid or the at-need SSD. Whereas the smarter way to go is to actually make this a thought when you're younger and when you're planning your general estate planning. What's become very popular, especially now that we have this enormous gift tax exemption, 11.6 million per spouse right now, which is just as large as it's ever been. It actually is the largest it's ever been. Is to create these family partnerships and irrevocable trusts now for the benefit of children, even if they're of majority. Usually we do that for children when they're minors and can't do it themselves. But the way by creating these type of trusts now, and these type of either family partnerships or other restrictive assets or restrictive vehicles now for the assets, is we're not only avoiding those things like probate and creditors and things like that, but you don't have to worry about that 2-year look back or any clawback from any transfers. So it's important to make sure that these assets are protected before you need to protect them. And that's true even from a lawsuit standpoint. I mean, we do assist clients with at-need asset protection, which is basically they're already being sued, or they have a judgment against them and they need to figure out a way to protect those assets. But we're much more limited in our options. Whereas if someone, and most of the time it's business owners that think about this ahead of time, but it should really be everyone, if someone created their estate plan with a way that it really did put some of the focus on asset protection and creditor protection, then what would happen is we'd also be able to protect when we're older, and then when it comes time to apply for those benefits if necessary. And if not necessary, no problem, because honestly, I mean, I know everyone here is from throughout around the country, but anyone here in South Florida knows it's the litigation capital of the world. So you have a 100% chance of dying, but the chance of being sued is just right under that. So I think that it's important to at least take that into account. I got another question here about a pooled income trust. Pooled income trust is actually a great way to get around that Miller income issue. What you want to do is you want to make sure, though, that if you're going to do something like this, you're only doing it for the income that's in excess. Because you don't want to make, if you're going to pool everything, you don't want to make sure that it's restricted in a way that you wouldn't have access to the income you need. A lot of times when we create these Miller trusts, which also can act in this form, we want it for only the excess, and we want to make sure that the person who's benefiting, they're not forced to have less than their usually adult children would want them to have. Most of the time, I prefer my clients to spend as much as they can on better medical care and stay at home. Don't go to a facility if you can afford it. The benefits are great, as far as qualifying for Medicaid and SSD, but not if it's going to limit your ability to live the way you want to live. I've had clients come in with excess assets and just saying, can you make me desolate and qualify me for Medicaid? And I say, why? Just get good home health care. That's the other thing I forgot to mention. I meant to mention this earlier. Anyone who can afford to, and especially the younger you are, the better, the cheaper it is. Long-term care insurance is great. I mean, having good long-term care policies, even, look, I'm 41. I got my first long-term care policy when I was 30. It's cheap. And it's indefinite. They don't have the indefinite policies anymore. And sometimes it has to be linked to a life policy if you're going to go longer than, 5 to 7 years, but all you really need is a 5-year policy. There's a 5-year look back on transfers when you're trying to qualify. All you have to do is make sure that you have 5 years of long-term care. Then when we create these irrevocable trusts to hold your assets, you're still getting that money for the care that you want, the care that you paid for those 5 years, and just make sure that it's a reputable company too. So if you're buying long-term care insurance, I always recommend a mutual company, usually more than a stock company, just because it's a little bit safer. But long-term care insurance is also a very important part of this process, if you can get it. I mean, a lot of times people, they come to me and it's already too expensive, or already their health kind of, it gets them out of that category of where they might qualify. But definitely that's a component too. In fact, one of the things that we do with clients when we're talking to them about their planning, be it, estate planning, asset protection, or supplemental needs planning, is to talk about the types of assets too, because assets are treated in a different component depending on what they are. Obviously, in fact, the biggest question I get is about houses, where they say, okay, well, my house, I need to qualify, I need to get my house out of my name, but there's an exemption for homestead. In fact, a big mistake I see, probably the biggest mistake I see, is when people put non-spouses on their house. So an adult child, for instance, it causes more problems than it helps with. I mean, the only thing it really does is it allows for that house to avoid probate at the time of death, but it causes capital gains issues, gift tax issues, property tax issues, homestead issues, because now you don't own half of it. And if you're going to apply for benefits, then there's a benefit issue, because now it's not necessarily just your primary home. There's an issue there where, okay, it's not just yours, somebody else is living there as well that you're not married to. There are different treatments for spouses versus non-spouses. So that's why if you put a spouse on there, it's one thing, but if you put an adult child in there, it's probably the biggest mistake I see in planning. I see another question came in. Alternatives to long-term care insurance. So this is one of those things where if health plays a part in not being able to qualify for life insurance or long-term care insurance, I always say liquidity is key. So making sure that you start to put away enough liquid assets into an irrevocable trust of some kind, keeping it out of your name, but making sure you're not spending it all if possible. I mean, not everyone has that option. Where I see a lot of issue is a lot of times I'll have clients that are very illiquid. So they can't get life insurance either because of their age or because they have some type of pre-existing illness. And then they have all their money in their business or in real estate or things like that. It causes a huge problem because those things are harder to move. They're harder to protect. They're also, at the time of death, harder to take care of because there's not any liquidity there for the kids to use, and the assets themselves are tied up. They also have overhead. So those type of assets with overhead are work as liabilities as well. Unfortunately, when it's someone who's young that's diagnosed with MS or any other type of condition that might make insurance either unattainable or just not feasible at the cost, then the most important thing is starting to put aside some of that liquidity, even if it's just as a little bit at a time, and making sure that that's there for when you do need it, rather than having to get rid of that asset, or that accumulation of cash if it's in your name at the time that you're trying to qualify for benefits. If you don't have the cash, then you can qualify for the benefits, and then there's not really an issue. It's you qualify for the SSD or the Medicaid or any other benefit, and then that entity will just pay the medical bills and take care of you that way. So unfortunately, it's those people that are in between. I always say that the client that comes to me with $3 million, I tell them just spend your money and stay at home. And the client that comes to me with no money, I say, well, okay, there's nothing for me to do really. I had a client that called me up a couple weeks ago, and she she was trying to get me to draft these trusts for her. And when I looked at her intake form and I saw her total assets were like $2,300, she didn't even have a house or anything. And I said, you don't need me. You know, you just apply and you'll get it. So I think it's, it's important also to not, spend money unless you have to on what I do. I always joke with clients, I don't want to turn down the business, but don't waste your money on me until you've heard that, from a Medicaid application specialist that you're not going to qualify with the assets you have or the income you have. Then we get on a phone call and we can decide, what's the best route. Sometimes, unfortunately in my field, there are what I call, drafting attorneys that basically when a client comes in and they say, I need this, the attorney just says, okay, what's your name? And just starts drafting it. And sometimes it's not the right thing. Sometimes someone reads an article online or in a newspaper and they say, oh, I need this. And then when they come in, they really needed something else. So I think it's important to have that conversation and to make sure everyone is having the conversation together. So the parents, the kids, the CPA, the financial advisor, the Medicaid specialist, the attorney, everyone needs to be on the same page. So that way there's not unnecessary work being done and unnecessary fees being spent. Let me see if there's any more. I think we're caught up on the questions. So one of the things that I also wanted to mention about, when someone passes, I kind of touched on it already. So a lot of people worry about, okay, well, when I die, do my kids then have to pay back what the government has spent? And that's where it comes in, the difference between the types of trusts and the assets versus the income. Depending on how long you live after first qualifying, and depending on if we're dealing with income that's been accumulated versus assets that have been protected, the answer is maybe. And in probate, always. In probate, there's no way, even in a summary administration, where we're dealing with a homestead or something, Medicaid will always come back in and they will get paid. When we talk about probate, which again, we all want to avoid, but if we have to go through probate, the list of how assets are distributed is first, the court gets paid, always. The taxes get paid, Medicaid gets paid, the funeral home gets paid, the attorneys get paid, then all the other creditors get paid, then the beneficiaries get paid. So all those entities are guaranteed their money. And then whatever's left over would go to the beneficiaries. If you don't have a will, that's done by Florida statute. There's an intestate statute that describes who the beneficiaries are. But if you have a will, then that you could pick whoever gets the crumbs, whoever gets whatever left over. But right, so that's actually all I prepared, is from a standpoint of what I wanted to talk about today. But I'm still fielding questions if anyone has any that haven't been answered yet.
If you do have a question, you can unmute yourself. And to do that, you would touch your screen or click on your screen, and you'll see a button that looks like a microphone with a red line through it. You click that button, and that will allow you to unmute yourself. Or you can submit your question using the chat.
I got a question here to just go over the Miller Trust again. So the Miller Trust is an income trust as opposed to an asset trust. When we need a Miller Trust is when someone is making too much income. So, for instance, a lot of times the income is something that people don't think is too much. It's maybe an IRA, an annuity, a Social Security income, and those are all adding together. We had one woman, it was mineral rights, just getting a ton of mineral rights from investments she had in the past. And the income threshold is very low. So once you go above that, Medicaid says, no, you don't qualify, you make too much money. When we create the Miller Trust, the idea is we're directing the income to that trust rather than directing the income to yourself, to your bank account. So once the money is directed into the Miller Trust, then you're qualifying for Medicaid. Now, the money that's in that Miller Trust can still be used for your benefits. The difference is, though, as opposed to the asset trust, is when you die, what happens to that money? So now whatever's left over in that trust does not necessarily go to your beneficiaries. Medicaid puts in a claim first against that trust and says, okay, we paid X amount of dollars, we get reimbursed now. And then sometimes there is money left over, and that money would pass to the beneficiaries through the trust. But many times Medicaid is, they take the money and that's their reimbursement. So that's why a Miller trust is not always the right move. It's a lot of my clients do require both a Miller trust for the income because they're not qualifying because of income, and also that irrevocable investment trust to manage the assets if they have too much in the way of assets. But sometimes someone has zero to their name as far as the asset test is concerned, but they're just making, $3,500 a month in income in retirement, and which doesn't sound like a ton of money, but it's, about $1,300 too much per month. So it's important to protect that. Then I see, can I put my adult children on all of my assets, IRA, home, to avoid probate? So here's where that number one rule of if they're not your spouse, don't have them as an owner comes into play. As far as the IRA, because it's a retirement account, it can only be owned in your own name, but you can list adult children as the beneficiaries of an IRA. The only downside to that is that inherited IRAs are not creditor protected. So if, for instance, you have, a son and a daughter and a son-in-law and a daughter-in-law, and maybe you don't want the son-in-law and daughter-in-law to get the money, it does become a marital asset. And it does, if one of your children predeceases you, it would, force that into probate potentially if you didn't have a contingent beneficiary listed. Other than that, having them listed as the beneficiary of an IRA is fine. But the other assets like home, bank account, brokerage account, never put a non-spouse on there, because what you're doing is opening yourself up to liability. So not only is there a gift tax issue and especially the property tax issue when it comes to real estate, and capital gains, but there's also a liability issue. So if my mother were to put me as the co-owner of her home because she said, okay, well, now it'll just go to Mike when I die, what would happen? And then I got sued. I got in a car accident. Somebody sued me. Half of her homestead is no longer protected from that lien. So if I had no assets and that asset was the only asset they could go after, they could put a lien against her house. That would cloud title if she needed to sell it. That would make it a problem, after she passed, because then the whole thing comes to me and now is susceptible to that lien. So there are some issues there from a liability standpoint. On the other side of that, if somebody slipped and fell on her property and they looked and they go, oh, well, Mike's mom doesn't have any money, but Mike seems to have money, they could sue me because I'm part owner of their home. So it's never a good idea to own a home with someone you're not married to. If it's a vacation home or if it's an investment home, own it in an LLC. If it's your own home in your own name. But when it comes to real estate, definitely don't put the kids on there. As a side note from a property tax issue, just a real life story, I had a client call me up that she said, my mother's having an issue with her home and we think we need a trust. I said, okay, well, tell me what's going on. She's the only child and she wants to inherit it free of probate. She saw a Susie Orman program or something that said, you should have a trust to do that. So she said, oh, I want to do a trust. But the problem we have is my mom put me on the deed of the property already. Her property tax was $1,000 per year. Now it's $5,000 per year. And it was because they reassessed. She had the home since 1987, and they had, homestead in Florida, it's capped at 3% per year increase on the value when they do the millage rates and figure out what you owe in property taxes. So she's now went from $1,000 a year to $5,000 a year in property taxes. There's also a gift tax issue, but that's only if you get audited. They'll probably fly under the radar there. Capital gains issue, because since she held the property for 30 years, the issue of when you die, you get a step up in cost basis normally, which means that the kids take it at whatever the value is at the date of your death, and then they can sell it and pay zero capital gains. That went out the window for half the property, because now since it's a gift during life, the daughter takes it at the 1987 value, not the 2020 value, although this was a few years ago, but you get it. And then they have to pay capital gains on half the property when it's sold. So all those things are an issue. So she said, well, can we reverse this? I said, we can reverse the deed. We could take, because your mom's still alive and competent, we could take the deed, we can move it into a trust, we could get it to you, we could protect it, we could get the step up in cost basis at death. That's no problem. Property tax, no, you're done. I mean, the Department of Revenue does not give back money. So the property taxes are not going to go down. So that part of it, I mean, even though we were able to correct the other part, she's now paying an additional $4,000 per year in property taxes. If she would have, instead of doing that deed, which she probably got from OfficeDepot.com or something, or LegalZoom, if she would have just come in and spoken to me beforehand, for a couple grand, we could have done the whole thing one time and avoided all of those issues. So, so as far as putting adult children on any assets, I always recommend against it completely. And then. So then, yeah, it's I got Greg's question. Can you call me after? Yeah, absolutely, Greg. It's no problem. But yeah, any other questions about any estate planning or asset protection? Just gonna. All right, just Greg. Okay, perfect. All right, there you go. Just putting my number to Greg. There you go.
Well, if that's all the questions we have, I want to thank everybody for their participation. I want to remind everyone that if you missed any part of this teleconference, that it will be available on the Multiple Sclerosis Foundation's YouTube channel. You can follow us on social media to watch for access information for that. We also do want to let you know, if your estate planning does include any kind of planned giving, we do have someone on staff who can help you to arrange your planned giving to the Multiple Sclerosis Foundation. Her name is Tracy Schur, and you can reach her by contacting the Multiple Sclerosis Foundation. You can call 888-673-6287 to leave a message, and Tracy will return your call, or you can email her at Tracy Schur, that's TRACISHUR @msfocus.org. I also want to let you know that we do have another teleconference scheduled for tomorrow. The topic will be Understanding Pain in MS, and that will take place at 2 p.m. Eastern. It will be presented by Adam Chaffetz and Adrian DeBerry. We hope that you will be able to join us. And if you need more information about that teleconference, you can reply to your registration email from this conference, and we'll get that information out to you. So thank you very much to Michael Wild, Esquire, for this presentation, this information, and all the time that you took to answer questions. We thank you very much for being with us today.
My pleasure.